Kia ora tātou, nau mai, haere mai, welcome. Ko Barry Morrison toku ingoa, and with me today from the National Office Boardroom is Keith Ballantyne, General Manager Southern, who I'm sure needs no introduction, and also Lee Williams in the background, and Lee will be feeding us your questions throughout the afternoon's webinar session. Our third of the year, and as a result of one of the most common inquiries that we get here at National Office is what to do through the membership disciplinary process. Please do put your questions in the chat, and Lee will read those out to us at the end of the presentation, and we will try to do our best today to answer those. And I'm sure between Keith and myself, we should be able to achieve that. This will be recorded, so please, you don't need to record it yourselves, and it will be available on our website in a couple of days' time. So like anything, let's get it right from the start. Does your club have a membership code of conduct that outlines clear guidelines for your members' behaviour? Do they know what they're expected to do? Do they know what they can and can't do? Just remember, you do not have to accept every membership application, and you don't necessarily have to give a reason why. Have proper procedures in place for admitting new members, and that will include having a membership induction evening where you will explain the benefits of membership to your club. You'll outline that membership code of conduct that we talked about before, and you'll be able to take questions from your potential members.
So, Mike, if you have gone through all the processes Barry outlined and you have sort of done things properly, and hopefully you won't need to get into this situation where you've got a couple of warring members, or you in fact have some behaviour that you want to deal with, you've got to firstly look at, has your complaint, has it been made in accordance with your constitution? Hopefully you may have adopted the fact that they have to use a standardised complaint form, rather than just a handwritten bit of paper, because of course a lot of things that'll be on that one, particularly if you use our templated one, it'll actually also ask, from the person who's complaining about somebody else, what is the outcome that they want to get from this process. So if you do get one, you need to investigate it. You want to do it promptly. You also need to decide, that will make your decision whether you need to take it further. Can it be resolved without a discipline hearing? If you've received a complaint about somebody and all they want is an apology, maybe you can have a chat with them by sitting them down and getting it through, so you don't have to go through the whole process of a discipline committee. A lot of your constitutions will also talk about the time frame involved here. Have we received the complaint within 7 days? Now, look, that's fine, but also be aware that some complaints, it may not come to light until 2 or 3 weeks later after the event had actually occurred. So really the time frame is about when you receive the complaint, because it could be the fact that it was something that you've only just picked up from your cameras, that somebody's been a bit naughty, and then make sure your time frames are right. Anything with this it's around your time frames. It's about doing things properly and being respectful to people. Of course, if you get it through it, you decide that no, look, this needs to go before our disciplinary committee, then you need to form that as soon as practical. Don't wait a month, don't wait 2 months, get it done as soon as practical.
Thanks, Keith. So that disciplinary committee needs to be independent and as free of perceived or real bias as it can be. Now, that can be difficult in a club, especially a smaller club. But to give you an example, there was a club in the North Island that had a complaint against its vice president. So you'd think it'd be a pretty well-known person around the club, but they were still able to convene an independent thinking disciplinary committee to protect those laws of natural justice, that there was free of any real or perceived bias, and that is critical. Major component there is that laws of natural justice and the removal of preconceived or real bias. A lot of clubs appoint or pre-appoint disciplinary committees, not necessarily the best practice to do nowadays, and especially under the new Incorporated Societies Act. You should be appointing a disciplinary committee on a case-by-case basis, and not some predetermined group that think they have the right to hear all and every disciplinary case that comes before the committee. One of the complainants could be a mate or best mate of a person on that disciplinary committee if it's pre-appointed, and therefore the case or any decisions that they make could be tainted by bias towards the complainant or the respondent. All members of the disciplinary committee need to act with complete discretion. Privacy is paramount. What stays in committee, happens in committee, stays in committee. Don't go rushing out to the learner of knowledge and spew out the whole facts of the case. Privacy, discretion, and remove the perceived or real bias. That is your focus of the disciplinary committee.
So, yes, you've just heard there very first, you used a bit of the rules of natural justice, and you will hear us talk about the rules of natural justice quite a bit. And the rules of natural justice is the overriding judicial, basically for New Zealand. So no matter what you've got in your constitution, you must abide by the rules of natural justice. So what are they? Quite simply, as Barry alluded to then, it's the rules against bias. So no person can judge their own case. The decision must remain completely neutral and free from personal, financial or official bias. And of course, that's also perceived bias, as Barry pointed out. The person has the right to notice. So authorities, in this case, it's the club, must issue a clear and timely written notice before any action, and they must state the exact charges and the claims against that person. Person has the right to a fair hearing. So that's, you can't just sit there and kangaroo court people. You must give them the opportunity to be heard, for them to actually state their facts and any evidence that they may actually have as well. They, of course, have the right to rebut and cross-examine someone. If the club is making a complaint about somebody, that person has the right to rebut and actually ask questions of the people bringing the challenge against them. And of course, the last part of rules of natural justice is around reasoned decisions. So authorities must record clear written reasons for their final choice. This provides and they apply that they had a mind fairly and allows for higher review. And of course, this is the big thing around all this. It's fine doing something, but if you get caught to task, authorities are going to look back at what you actually did. And like anything, if you don't record what you've done, you are opening up yourself to all sorts of things. So in that one as well, of course, with Clubs New Zealand, we have provided quite a few templates for things. And one of them you'll also see. So when you make your decision, you're writing to that person, telling them the decision, and you're saying why the committee or the discipline committee at that stage had made their decision. So if you do getting into that stage, you've got your disciplinary hearing. Once again, make sure it's held as practically as soon as you can after receipt of the complaint. Don't sit on it forever and a day. Get it done in a timely fashion. Follow your constitution, but also look at the things that we've said. Make sure that everything's been done correctly. Make sure your respondent is provided with all the details of the complaint, as we just said there with the natural laws of justice. And of course, make a considered and prompt decision. Don't sit on it for months thinking, oh, we'll just think about this for a bit longer. No, you've had your meeting, make a decision, and of course, get that back out to the person.
So you've gone through that process, you've elected a neutral committee, you've heard, they've provided the parties with all the evidence, they've cross-examined, you've got all the information you have, you've made your decision. Key question, does the punishment fit the crime? Does it create precedents? Is it in line with similar episodes that you've had to deal with in the history? Consider everything that's been presented to you, including, is this a repeat offender? Have we had this problem pop up with this person before? Be consistent. Don't go 3 months for one person and then 12 months for the same offence for another person, because they'll only ask questions. Oh, he only got the lightest sentence because he was a mate of the president. Again, removing that bias element, that perceived bias of natural justice, ensuring that those are upheld at all times. As Keith said, you've got to be able to back your decision if it goes to a higher authority. And your decisions, your deliberations will be a key part of your case. Ensure that your decision is provided for in your constitution, that you're not going outside of your constitution in the punishment, that the processes have been followed as outlined in your constitution, and ensure that your decision always is made within the best interests of upholding the reputation of the club. So once your decision's made, the respondent only has the right to appeal if they disagree. If that's the case, and that is their right, then you've got to select a new committee. And then you hear all of the information at that point in time. And if that new committee, the appeals committee, getting all the information, have considered that the original decision was fair and just, or otherwise, the appeals committee decision is absolute final. There are no further challenges. It cannot go elsewhere. So this process doesn't go on for years and years. It is, once the decision is made of the appeals committee, absolute finality that all parties must accept.
So recapping, as Barry sort of alluded to right at the start, if you get your membership admittance and your education processes right, if you have that code of conduct, people understand what is expected of them as a member, you're going to alleviate a lot of these concerns. And, you know, hopefully you won't get too many things occurring within your club. But make sure you've got them. Let people know what's expected of them. Have that induction, have that code of conduct, which you can give. It can just be an A4 piece of paper. It outlines people exactly what's expected of them. Follow your constitution if you have to go and get into a disciplinary type process. Don't just go, oh, we'll just do this because that's the way we've always done it. No, look at what it states in your constitution. Follow it. Follow the process. At all times, follow the process. Follow those laws of natural justice. It's the guiding light of all New Zealand judicial systems. So it is the same for a club. So make sure you follow it. Investigate promptly to determine if that hearing is required, as we've said. Not all these things, the wee bit of disputes between members needs to go to a disciplinary meeting. If you've got them to fill out that form and they say, look, all I want is an apology, maybe you can just sit down with the person and you can just get them to do that and not have to go that far. But if you are, do it as soon as practically. Don't let it fester because it only gets worse. As Barry alluded to, making sure the punishment is consistent and fits the crime. And remember that every time that you do this, you will set a precedent. And yes, if you, because he's the mate of the president and you let him off and you tell him, we're going to slap you with a bus ticket, basically you're going out there to your membership saying that behaviour is okay. It doesn't matter who it is. If somebody has gone through this process, then you must make sure that the punishment is consistent and fits the offence, otherwise you will set that precedent. And of course the last one, and this is where one of our clubs fell and it ended up costing them $100,000 at the High Court. The respondent has the right to appeal. So it's one of the founding bits of the natural laws of justice. They have the right to appeal. If they don't like it, they can appeal it.
Well, thank you everybody for joining us on this webinar. We hope you've managed to get something out of it. As Keith said during the presentation, we've got some great resources available in our members area, and we're continually revising and updating those as the legislation changes. Also, our governance and club fundamentals training session provides some valuable information when Keith and I are going around the country. Check your training schedules for when the next one is in your area and encourage your committees and your management teams get along to those. So I guess, what questions are out there, Lee? What questions have we got come through the chat?
Just while Lee's looking at that, guys, one of the things that we'll say is, remember with anything like this is take a breath.
Yeah.
Don't shoot from your hip, because if you do, you'll probably get it wrong. So anything like this, take a breath. You don't, when we say you don't wait a month for taking a breath, you just take that time just to think about this and go, right, are we doing the right thing? Second, question yourself before you go and make a mistake.
I think I did see, yes, a couple of questions coming through, I can see.
How would you manage a member with onset dementia that is progressively getting worse?
You'd probably enlist age concern, or their family, if they've got family. Obviously, you take each case by case, and there's mitigating factors in that particular member, but I would look to enlist the professionals for that. That is probably beyond the realms of many club members' scope of knowledge and ability to deal with.
It's probably not a disciplinary matter. It's something in years. I've had members, one of them signed himself back out of hospital 2 days after having his foot removed. And he comes into the club and he's got a bandage around his ankle and it's still bleeding. I had to have a conversation with him and say, look, and it's the same, if they've got dementia and you can't talk to them, then you need to talk to their immediate family. Just go, hey, look, it's not safe. This is not a safe environment for these people to be in.
Yeah.
What happens if the complainant chooses not to appear in front of the discipline committee?
Sorry, Lee, what was that again?
The complainant chooses not to appear in front of the disciplinary committee. What happens?
If they've been given plenty of notice and all the information, then the hearing can still proceed.
Can still proceed, but
Yeah.
Are you going to, if you're having conversations with those people, what's the reason for them not wanting to appear? Do you hold a lot of it's like receiving an anonymous letter complaining about something? If they're not prepared to put their name to it, if they're not. Yeah. This is a process, and the person complaining as well needs to know that this is a process. So when you're getting somebody and you're talking to somebody about filling out a complaint form, you've got to let them know that, if this goes to disciplinary, you will be required